Welcome to our Foreign Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is a US-based docketing and paralegal service provider that focuses on using technology and automation to provide the highest level of quality available today in our services. The SLW Institute is an educational group created by the Schwegman Lundberg Wissner firm, which aims to provide insightful and useful information to the IP community. For the webinar series today, we have pulled together experts to talk about strategies and best practices for patenting in key foreign countries. The Foreign Excellence webinar series is free. This is one of several monthly webinars in this series that we've already put on. The schedule and registration information for upcoming webinars, as well as the recordings from previous webinars, are listed on our website. To register for future webinars, go to the tab for Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today will cover India. We have allowed time for questions at the end of the webinar. However, you can submit questions at any time during the program using the question box in the control panel that should be on the right-hand side of your screen or browser window. You can submit a question at any time, as I said, but we'll hold that question in the queue until the end of the presentation and then discuss them. The presenters today are myself and Malati Lakshmi Kumaran and Mr. Ankur Garg. I'm Ann McCracken, the president of Black Hills IP. I've been a patent attorney for 21 years, working in the patent prosecution field in the US. I was a partner at the Schwegman firm for 10 years, and I was also a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. With me today are two presenters from the firm Lakshmi Kumaran Sridharan in New Delhi, India. First, I'd like to introduce Miss Malati Lakshmi Kumaran. She has a PhD in biochemistry, and she worked as a scientist for 25 years before transitioning to the intellectual property field. She's a patent agent at the firm and focuses on drafting, filing, and prosecution. In addition to that, she oversees the IP operations within the firm. Presenting with her is Ankur Garg. He's an engineer with a background in electronics and communications. He spends a lot of his time focusing on drafting and prosecution work for multinational companies, particularly in the telecommunication and software field. He's a lawyer in India, which means he can both represent his clients in front of the patent office as well as the courts. He's been with the firm for 9 years and is a joint partner at the firm. And just a quick comment on the firm itself. This is a full-service firm in India with a very large IP practice, both on the prosecution side, and they can also do litigation as well. So I'm very happy to have the two of you with us today to present. Today we're going to be discussing various aspects of patenting in India. First, I'm going to look at some data on filing trends in India, and then our panelists will talk about some very specific details on the patent process in India. So let's go to our first slide. This slide, as some of you who've been listening to this series for a few months know that we're comparing the markets as a backdrop for this discussion across the countries that we've focused on in this webinar series so far. So looking at this slide, the 8 countries other than the US and India are the ones that we've already discussed on previous webinars. And if you missed those, again, you can go and listen to those on our website. Using the GDP as a measure of the economy size, the US has the largest economy in the world, and you can see that's followed by China and Japan. But then of the countries that we've focused on, the size of the economy in India ranks 7th worldwide based on GDP, which makes it larger than many of the other countries that we have focused on so far. And India, as you can see, also has a very services-based economy. The next slide shows the top technology areas for patent applications filed in India by any company, whether it's a local Indian company or a non-Indian company such as a US company. It's probably not surprising that the top technology areas for filings in India are both computer technologies and pharmaceutical technologies. Those are followed closely by organic and fine chemistry, and then you can see the rest of the technologies there as well. Next is the top patent SMEs. The companies in this category are the companies with the most patents granted in India in the year 2016. And here we can see that a US company, Qualcomm, was the company with the most patents granted in their name in 2016, with over 100 patents granted in their name that particular year. Next, we will look at the filing trends. Get my slides advanced. There we go. So the filing trends that I'm looking at are filings by non-residents, and this is a WIPO term. The term resident is used for filings made by applicants at their home patent office. The home patent office meaning it's the national patent office or the regional patent office in their country. A non-resident means it's a filing made by somebody in a foreign patent office. So in other words, when the patent office in India receives an application filed by a foreigner, it's categorized as a non-resident filing for that office. So you can see here the bars are grouped by year. Again, looking at the different countries that we've focused on so far and comparing which countries have more non-resident filers, we can see that the number of non-resident applications filed in India, which is the dark bar on the right in each of the groupings by year. Interestingly, that bar has dropped only slightly, but ever so slightly over the last 5 years, from a little over 34,000 applications filed by non-residents in 2012 to a little under 32,000 in 2016. But that's still higher than the amount of non-resident applications being filed in Singapore, Malaysia, Taiwan, Mexico, and Canada. So there's still quite a few. Okay, next we'll take a look at patent grants. Again, this is organized the same way, year by year over the last 5 years. And the numbers for India are on the bar on the right side, the darker colored bar. The number of patents granted in India to non-residents during the last 5 years has increased, and quite significantly. You can see from 3,600 patents granted to non-resident filers in 2012 to over 7,000 patents granted to non-resident filers in 2016. So there's been quite an increase in the grants. Next, let's look at the patents in force. Similarly, and as you might expect, the number of patents in force total in the country of India have increased over the last 5-year period. And then finally, let's look at some cost data. So the cost estimates that we present here are prepared with a commercial software tool called Global IP Estimator. That's a commercial tool that's available from a company, I believe, called Quantify IP. The estimates include both the official government fees and an estimate for the foreign agent fees for the life of the patent. So you can see for India, the lower portion or darker portion of the bar is the estimated cost from filing to grant of a patent, and that is around $8,700 US. And then the annuities are about the same, slightly higher. You'd expect about $9,700, $9,800 in annuity payments over the lifetime of the patent. So the total cost to acquire and maintain a patent in India is, on average, roughly about $18,000 US. So with that as the backdrop, I'm now going to turn the program over to our speakers. We'll start with Dr. Malati Lakshmikumaran. So I'll turn it over to you.
Thank you, Anne. And it's a pleasure to be talking about the IP practice in India. Can I have the next slide? We're going to do an overview of what is in India. The next slide, Anne.
Mm-hmm.
Next slide. So, as Anne explained, it is a very big country. It's the second largest country by population. And as you see, we are a service industry type of, and also a lot of farming. So what I'm going to do today is do an outline of the India IP regime. Anne has already done quite a bit. I'll just give quickly about the IP regime, the basics of Indian patent law. I then go to the examination of the application, and then I touch about non-patentable inventions, both in the pharma and non-pharma area. We also talk about foreign filing license, Section 8, and working statement. The next slide, Anne. Just to give an outline of the Indian IP regime. So if you look at the different types of IP that we have, so we have the semiconductor layout in Delhi. Patent offices, we have 4 patent offices in India, with Calcutta in the east, Delhi in the north, Chennai in the south, and Mumbai to the west of India. It's a large country, and that's why we have 4 offices based on the different geographical regions of India. The designs office is in Kolkata. So you could file it in any, but it will all be examined in Kolkata. The trademarks registry, we have 5 offices in India, with Mumbai being the head office, followed by Delhi, Kolkata, Chennai, and Ahmedabad. So we have 1 extra office other than what we have 4 in patents. There are 5 in the trademarks. The geographical indications, that registry is in Chennai in the south of India, and the copyright office is in Delhi. Now, all these comes under the Department of Commerce, and that's why I talk about this. We do also have plant variety protection, but that comes under the Department of Agriculture, and we're not talking about that today. The next slide. I just give in this slide about the patent trends in India. As you saw with what Anne presented, there isn't too much of disposal, and there is a huge backlog of patent applications that haven't been examined. And so the government of India really said, let's do something, and decided to hire a lot of examiners, and so to actually take care of the backlog of patent applications. So if you see roughly in the last couple of years, we've had about 45,000 to 47,000 applications being filed. It's sort of flat. But if you see the next thing, which talks about how many applications have been examined, so in 2015, it was only about 16,800 and odd applications that were examined. It went to about 28, 29,000 in year 2016-17. But this year, 2017-2018, that is that year which is just completed in March, 60,000 applications were examined by the patent office. So there's been a huge rush, and a lot of patent applications are also being prosecuted. They're examined, and they're being prosecuted as well. So if you look at the next tab, which is on the grant, we've again seen a rise from about 6,000 and odd to 9,000 to about 13,000 granted this year. And if you look at the disposal, there's been a huge thing from 21,000 or 22,000 to about 47,000. So if you look at it, we're only filing about 45 to 47,000. But if this trend continues of getting 60,000 applications being examined, I think the backlog will be cleared in a couple of years. And the Government of India wants to get this backlog done by 2020. Next slide. If you look at the next slide, I talk also about the trademark trends. Here it's a little different. They've also had a huge backlog, and they had about 270,000 to 280,000 applications being filed every year. But last year, they examined more than 500,000 applications of trademark. And this year is about 300,000 applications of trademarks that were examined. And if you see the registered, there are more than 300,000 trademarks that were registered this year. So in trademarks, it's a lot domestic filing more than international filing. And the disposal also, you see, it's more than 500,000 this year. So they're trying to backlog, and now you can get your trademark registered in less than 6 months. So this is a positive sign that the Patent Office and Trademark Office is trying to tell the people that we will be quick from now on. The next slide. We have the next will be on design trends. I don't want to take too much time on this. So it's filed about 10 to 11,000 applications get filed on a year-on-year basis. And a similar amount gets examined as well, so they don't have too much of backlog. And within 6 months to 1 year, you can get the registration of your design. And so about 10,000 have been registered last year, which you see, which is in line with the number of applications for designs that are filed. And they also dispose that many number, about 10,000 every year. So this design doesn't have too much of backlog. The next slide is about copyrights that we'll be talking about. And so if you see, we had about 23,000 applications filed this year. They're also examined about 26,000. There isn't too much of backlog. The registration is also about 20,000, and they've disclosed more than 32,000. So copyright, there isn't too much of a backlog. And this is something new that the Patent Office is taking, and it has been shifted to the Department of Commerce. And so it's right now in the Patent Office in Delhi. Next slide. I will be talking about the basics of Indian patent law. This was more the trend and the statistics. And the next slide, I'll be talking about what are the patenting processes, an overview. Next. So this, as I said, we have 4 patent offices in India. And so the filing of the application can take place in any of these offices. For Indian applicants, it has to be in the jurisdiction where they are located or the head office is located. So we have Chennai, Delhi, Mumbai, and Calcutta as the 4 patent offices. And when you file an application, it gets automatically published after 18 months. We also have a substantial examination procedure in India. And so every applicant will have to file a request for examination. And if you file the request for examination, the Patent Office will examine those applications. If the applicant fails to file the request for examination or submit the forms for request for examination, that application will be considered withdrawn or lapsed. So this is an important step, and is generally 48 months from the earliest priority that you have to file the request for examination. Once it is taken up for examination, the Patent Office will issue the first office action, which we call as the first examination report. And if during prosecution you have 1 or 2 office actions or a hearing, and it can proceed to grant. However, in India, we have 2 types of opposition proceedings. One is called the pre-grant opposition by any person, and this happens until the grant of the patent, and it is used by several people to actually oppose patents. It could be in the area of pharma or any other area as well, but it's generally used a lot in the pharmaceutical sector. After the grant of the patent, we also have a post-grant opposition procedure, which is 1 year from the date of the grant of the patent, and that is filed in the patent office, in the respective patent office where it was granted, and the patent office will review it, will call you for the hearings, and so on. But if the 1 year term is over from the date of grant, then you have a revocation proceedings, which you would then put at the appellate board. So that is also, but that post-grant and revocation can only be done by a person interested and not by any person. After the grant, of course, the payment of annuity fees to maintain your patent. If you don't maintain, the patent is lost, it's lapsed. Next slide. I next talk about the process in little detail about how you file the applications. India follows, we are also a member of the PCT, so we follow you can go through the convention route, you can go through the national phase application, or you can also have first filing in India. I will be talking about foreign filing license, and I'll say about that as well in the later part of my presentation. So India follows the 31 months time limit from the earliest priority to file a national phase application in India. You can file it earlier. This date, 31 months deadline, is non-extendable. So you have to file it within 31 months from the earliest priority date, and there's no way. There are court cases. We have jurisprudence on this. The Patent Office has also made it very strict by having a rule that absolutely no extension of this 31 months date for entry by the national phase from the earliest priority. The specification is like in any other. It's got title, description, drawings, and you can amend your specification. When you enter through the national phase, you either enter with the claims that are at the PCT stage. It can either be Article 19 or Article 34. At this stage, you can only delete the claims. You cannot amend the claims in any other form. However, if you want to do voluntary amendments, you can do after filing of the national phase application by using Form 13. And also you cannot expand on the scope, you can only narrow down the scope by way of voluntary amendments. Next slide. I would now talk about the examination. Next slide. How do you do request for examination? As I said, India follows the substantial examination. Just filing the application, it will not be taken up for examination. So we have something called request for examination, which has to be filed within 48 months from the earliest priority. Again, this date is not, the deadline is not extendable. And if you do not file the request for examination, the application will be withdrawn. Any national phase application will only be examined after 31 months. If you want early request, you can have an express request for examination. Now, India does have something called as the expedited examination, but that is only for Indian startup companies. It's not for any others, and they have to get a number from the DIPP, which is the Department of Commerce. The other route for doing expedited examination is if the applicant chooses India as the International Search Authority during the PCT application, and it cannot be done for any others. It has to take India, you file in India, and use India as the ISA. Next. What about examination of patent application? Once it goes into the queue, into the examiner's queue for examination, the controller, they have an examiner, the examiner's boss is the controller will issue a first examination report. And the application has to be put in order for a grant within 6 months from the issuance of the first examination report. The 6 months deadline is not a deadline to file your response, but the 6 months deadline is to put your application in order for a grant. This date is extendable by 3 months on payment of official fees is about $250. Now, if you do not respond to the first examination report, the application is deemed to be abandoned. Most of the times you will see that we do respond within 6 months and the controller would not have come back. There's nothing to worry as long as you have complied with all the objections raised in the first examination report. If the 6 months deadline or your extended deadline of 9 months, that is 3 months extension that comes out 9 months, is over, the controller will call for a hearing and he will give you a chance and give you a hearing, and he cannot reject the application. So this is many times we ask questions, people ask questions, what happens? You file it, but now the patent office has many examiners and it has quickened the pace as well. Next slide. I'm going to talk about non-patentable inventions, my next set of slides. Again, next slide. I talk about, we are putting it in two parts, which is one, this patent about non-patentable subject matter is more for biotech, pharma and chemistry type of applications. As Anne had explained earlier, India is strong both in pharma as well as in engineering, mainly in software and telecommunications, to some extent in engineering. And therefore, you will see that there's a lot of stress on applications being filed in the area of pharma and biotech. However, just like in any other jurisdiction, we have to pass the test of patentability, which is novelty, inventive step, and capable of industrial application. In addition, we have a section 3, which talks about non-patentable subject matter. And what that says is, what inventions will not be allowed a patent in India? So we do have section 3B, which is contrary to public order and morality, very much like how it is in Europe. 3C, which is discovery of living things, very similar to the Myriad judgment in the US, where a living microorganism or even a DNA or a protein, if it's considered to be the same as in nature, will not be granted a patent in India, will not be allowed. Claims directed to microorganisms or DNA or protein, which is same as in nature, will not be allowed a patent. So this is very much like the Myriad. But the next one that I talk about is section 3D, and this is where India is different from most other countries. We have a section which says new forms of a known substance. So India was strong in pharma, and therefore they would not like to give for a lot of inventions which are secondary inventions. So what do I mean by a new form of a known substance? So if a compound is already known, so you will not be able to get a patent for a crystal form or a polymorph or a salt form of the known substance, unless and until it shows enhanced efficacy. And the courts have understood, and the courts have actually interpreted what is enhanced efficacy as saying enhanced therapeutic efficacy. It's not that India doesn't grant for new forms, but there is a bar which is much higher, and you need to show therapeutic efficacy for a new form of a known active ingredient. So this is the most difficult in India for 3D, but that's only related to pharma and chemistry applications. 3E is compositions, mere admixtures of known molecules or known substances or known compounds is not patentable. If the ingredients are known substances or known compounds, you need to show synergistic effect. This is very much like in other countries where you have to pass the bar of inventive step. The next is 3I, which is a method of treatment of animals and humans, which is not patentable in India, very similar to Europe. And so any method with an administration of a drug or administration of a substance or molecule will not be patentable. However, compounds, kits are patentable in India. Section 3J, plants, animals, and parts thereof, is not patentable. However, microorganisms are patentable subject matter as long as they don't fall in the discovery clause, which is section 3C. And here the patent office will allow claims to prokaryotes like microorganisms, fungi, and so on, but will not give for a plant cell or an animal cell, will not be allowed a patent for. Similarly, essentially biological process for the production of plants and animals is not patentable, but anything that forms under non-essential, like if I do genetically transform a plant or genetically transform animals or cells, such type of thing which has a lot of human intervention is patentable subject matter. This is very similar about essentially biological process like what you have in Europe. Traditional knowledge, section 3P, is not patentable. This is more in most countries, it would be novelty. However, India has brought this about 3P, and the patent office will have to show that this is traditional knowledge, and that is why it is not patentable. The next slide. I would now talk about, I would now give this mic to my colleague Ankur Garg, who's an engineer and a lawyer, and he will talk about the relevant sections in the engineering area.
Thank you, Dr. Malti. Now I'm going to discuss about some of the sections which are related to engineering matters, which sections relate to aspects which are not patentable relating to mechanical, electronics, or computer-related inventions. We have a section 3F, which states that mere arrangement and rearrangement of known devices or known mechanisms is not patentable. Then we have section 3K, which is essentially a section which is attracted in almost all computer-related inventions, which says mathematical or business method or computer program per se or algorithms are not patentable. One thing that we need to notice here is that there is an absolute bar for mathematical or business methods or algorithms. However, computer programs are not absolutely barred, and it's only computer program per se which are barred in India. Then mere scheme or rule or method of performing a mental act is also not patentable, and also method of playing game is also not patentable under 3M. Similarly, any form of presentation of information, either in the graphical form or any other form, is not patentable under 3N. Next slide, please. Now I'm going to talk slightly in detail about section 3F. This talks about that mere arrangement and rearrangement or duplication of known devices is not patentable, especially in conditions where they are functioning independently of each other and they are functioning in the known way as they would have functioned independently. We see that generally this objection is raised along with conjunction of inventive step objection, and especially mechanical cases where devices and apparatus involve known elements, this objection is very common. To respond to these objections, we generally rely on proving that there is a synergetic effect between the devices and apparatus involved and they are not independently working. And we also definitely put across arguments for providing the inventive step and establishing it. Next slide, please. Relating to section 3K, as I discussed before, mathematical and business methods and algorithms are an absolute bar, but computer program per se is something which is slightly of a gray area. It is very similar to Article 52C of EPC, which talks about scheme, rules, and methods of performing mental acts and programs for computers and playing games or doing business are not patentable. So similar to Article 52C, in section 3K, we have about computer program where anything which is specifically oriented towards computer program and not giving a technical effect is not patentable. So I'll discuss 3K and specifically about computer program in detail in next slide. Next slide, please. So because the aspect of computer program per se is still a gray area and there is no defined boundaries as to what will be patentable, the Indian Patent Office has actually tried to define through different guidelines, computer related invention guidelines from time to time, and this has been evolving since 2015. So the first guideline was actually released in August 2015, which was withdrawn, and then later 2016 we had another set of guidelines, and finally in 2017 June we have the final revised guidelines, which actually emphasize on identifying the claim as a whole. The previous guidelines of 2015 and 16 actually included certain aspects where if there is a novel hardware involved, then only a computer program will be patentable. A lot of applicants and stakeholders actually discussed this with DIPP, and thereafter the 2017 guideline that has now been released is much more in line with what the objective of the legislation is, and it more focuses on how to identify the technical effect and contribution of the claims rather than merely seeing the hardware involvement of different entities into the claim. The mere recitation of mathematical formula also does not make a patent ineligible, and also there has been a welcoming introduction into these guidelines which state that just because there are certain terms which have been used like business rules or commerce or enterprise or supply chain, it will automatically not make the claim as a business method. So if you are analyzing the claim as a whole, it will be treated if there is a technical effect and it is making the technology better, certainly it would not be rejected under 3K. Next slide, please. So now I'm also going to talk about foreign filing license. India has a requirement of foreign filing license where an Indian resident, if he or she wants to file an application outside India, they would either have to take a foreign filing license from the Indian Patent Office, or they would have to first file an application in India and wait for 6 weeks before filing the application outside. Filing a PCT application with the India Patent Office as the receiving office is also a violation of Section 39, and either a foreign filing license is to be sought before filing such PCT application, or a first application in India with the Indian Patent Office needs to be filed, and then after 6 weeks, the corresponding PCT application can be filed. Next slide, please. I've actually tried to explain the foreign filing license requirement through an example. The requirement that the Indian patent law has is that if there is an Indian resident and an application is to be filed by them outside India, they need a foreign filing license. Now, to identify whether a person is an Indian resident or not, there are two criteria. First is that if the person has resided in India in the past year for more than 183 days, then the person is considered to be an Indian resident. India as a country follows a financial calendar year rather than from January to December. So if an application is to be filed on October 2nd, 2018, the year which will be considered for calculation of this 183-day period will be between April 1st, 2017 to March 31st, 2018. If any person has resided in India, then either a foreign filing license has to be taken before filing an application outside, or a first filing has to be done in India. It is also applicable if a person has resided in India and the invention has taken place outside India, then also the applicant, the resident, is liable to take an foreign filing license from India. Similarly, a second situation is also available for determining whether a person has been resident in India. So if in the past 4 years, if the person has resided in India for 365 or more days, including residing in India for more than 100 days in that year, then that person would be called an Indian resident. In either of these situations, either a foreign filing license is required from the Indian Patent Office, which generally takes about 2 to 3 working weeks to grant, or the first application needs to be first filed in India. Next slide, please. So now we're going to talk about Section 8 requirements. I will now hand over the mic to Dr. Malti. She will talk about this.
Next slide. I will be talking about Section 8. Next slide. I will be talking about Section 8. It's very quick. It's just that we get a lot of queries on Section 8, and so I thought we'll talk about this in today's webinar. This was introduced. It's very similar to the ideas that you have, but where are we different? What we tell our applicants is it's very important to comply with Section 8, because this can be one of the grounds for revocation of the patent, and therefore it's important. It's very simple, and it's better to comply with it. And it can also be, if you have not complied with Section 8, it can be one of the grounds, and you may not get preliminary injunction. Can I have the next slide? Now, I talk about Section 8. There are two parts to Section 8. First is Section 8.1, and the other is Section 8.2. So first I talk about Section 8.1. What is Section 8.1? It's a form that you need to fill up, giving you the list of all the corresponding applications with their filing date, if there's an application number, and their status. So it's just a form. When do I have to fill this form? The first Form 3 that we call, which is to comply with Section 8.1, has to be filed within 6 months from filing the Indian application. The Indian application can be a direct application, can be a convention application, or a national phase in India. So from the date you enter into India, within 6 months, you need to file a first Form 3 giving the list of corresponding foreign applications, the PCT applications, along with their number and the status. It could be pending, it could be granted, it could be allowed, it could be opposed, and so on. So this is very important. If you do not do that, it can be a ground for revocation. So it's important to comply with this. When do I file the next Form 3? A lot of people would say, oh, file it every 6 months. I don't think that's the right way. Next Form 3 gets triggered when you have a new application in that family. So if you have filed a divisional or a continuation application or a continuation in part application in any jurisdiction, then you have to file a Form 3, which is called as the updated Form 3, within 6 months from the new application in that family. So if a new divisional application was filed, let's say in Japan or in Europe, then the date of filing the new application in that family would trigger for us to file the next Form 3. So this is where it is. It's pretty easy. We can just keep updating the status of the different foreign applications in that family. There's no obligation that you keep filing the status update. However, there is a thing called a same or substantially the same application. And so if there are overlapping patents or related applications, such information has to be given. It could be in the pharma area. We do have related applications with common priorities. And so it's important, even if the PCT is different, if there is overlapping information, overlapping claims, you need to file these applications or status of those applications as well in Form 3. Can I have the next slide? I would now talk about Section 8.2, which in Section 8.1 in my previous slide, the obligation is on the applicant to submit Form 3 and to submit updated Form 3. And what we also say is, as you file and you get an office action, we need to file an updated Form 3. So Section 8.1 obligation is on the applicant, and we don't have to actually give when the patent office asks. However, Section 8.2 is slightly different. The 8.2 starts only when the patent office requests the applicant for Section 8.2. Hello, Anne, can you hear me? Hello? Just right there.
Sorry, go ahead.
Okay, thank you. So in the section 8.2 is an obligation is only when the patent office requests such information. Otherwise, there is no information required to be submitted to the patent office. Here, what is it? It's to be given only when the patent office asks, and generally they'll request in the office action, either in the first examination report or in the hearing notice. How do you supply it? What do you ask? So you have to read what the controller is requesting. He could ask you for updated Form 3. He could give you copies of office actions, responses, claims. It could be allowed, amended, or rejected. Mostly he'll ask you office actions, responses, and claims. Responses very, very rarely, but copies of office actions and claims. And these are mainly from major jurisdiction that they'll ask. Machine translation of the office actions or granted claims is also sufficient. Now, what do they mean by saying which countries are they relying on? What are these major patent offices? So mostly the controller will say, provide office actions and claims from major patent offices. So you look at the corresponding applications in US, EP, and Japan and provide copies of office actions and granted claims or allowed claims. Sometimes you have a request for all patent offices, and that's the time when you have to be worried, and please do it. What could also happen is you can also have, we've had several, you have to be very careful. When they ask you for section 8.2, we have to write and we have to submit what the controller asks. Can I have the next slide? I will talk about working statement in my next slide. Next slide. This is a requirement after the grant of the patent. If the patent is granted in 2017, we are obliged to file Form 27 to tell whether the patent office, whether it is commercially worked. You have to say whether it's worked or not worked. If it is not worked, you need to give the reasons why it is not worked. And if it is worked commercially, you need to give the price and quantum. Now, if a failure or refusal to comply with submission of Form 27 can have penal sanctions, a fine, or it can also lead to compulsory license of the patent because the applicant has not commercially worked this application in the territory of India. Importation of the product or a kit or the process is also considered to be working. It doesn't mean that it has to be filed only in India. Can I have the next slide? The framework is for the enforcement of India. You can enforce it before the court of law. It can also be by border enforcement, IP revocation before the patent office, pre-grant, post-grant, I've talked about it. We have the IPAB board, and it can also be in any of the high courts. Can I have the next slide? We have the commercial courts in India, and in the commercial courts, it used to take many years, but now within 15 to 18 months, the whole case can be sorted out and you can get the judgment. I don't want to talk too much. I think we are exceeding our time. Next slide.
Malati, is that the commercial courts one? Okay.
Yes, that's the commercial.
So back to me?
Yes, back to you.
Thank you very much, Dr. Malati and Mr. Ankur Garg. I think you guys did an excellent presentation. At the moment, I just want to remind the audience that questions regarding today's program can be submitted in the question box on the control panel on the side of your screen. If you have questions generally about Black Hills IP Services, please contact Jim Brophy, our Vice President of Sales. If you want more information about the SLW Institute, please contact their Program Director, Brian Ness. And we also have the contact information on the earlier slides for Dr. Malati and Mr. Ankur Garg, and I'm sure they'd be happy to talk with any of you about their firm's services or Indian patent law questions. I don't see any questions coming in other than I do have one comment that this was an excellent webinar, and I want to share that with the two of you as presenters. I also want to remind the audience that we will post the slides and the audio recording from today's program on our website. That again is blackhillsip.com. This will take us a couple days, but we will have these posted and available. You go to the Our Educational Resources tab, and you'll be able to find them there. And then just also want to mention that the next webinar in this series is on July 22nd. We will be focusing on filing directly in Germany and the patenting process in Germany. So again, I want to thank both of our presenters today. Oh, actually, you know what? I just want to pause. It looks like we do have one question, and I think we have time to take that. So the question is on the Section 8.1, First Form 3, requirements stating the filing particulars. Do you need to enter the date of the national filing or the PCT date? What date do you put on that first Form 3 for Section 8.1, the PCT date or the national filing date?
Okay, this has been a question that many people ask us. Actually, according to the guidelines as well as the rules, the date of the application in Form 3 has to be the date it actually entered the in different jurisdictions. However, in the first Form 3, you could give the international filing date and put that. That's the easiest because it will come from your docketing system, and so most of them do give the international filing date. That's for the first set of applications. However, the thing starts is when I file a next application, which is a divisional or a continuation in any other jurisdiction, and you end up giving the international filing date, the controller could say that you did not comply with the updated Form 3. So when you file the next Form 3, we have to be careful, and it's better if you can give the new date of filing. However, if you do file with the PCT date, they also have to give a justification to say that we did file the updated Form 3 within 6 months from the new application that is filed in this family. So basically, the date only helps us to know when did you enter or when did you file a new application, and did you comply with Form 3 requirements within 6 months from any new filing in that family. So for right now, I know for docketing purposes, it's much easier to put the PCT application date, but if there is a query from the controller, we could ask you for the exact filing date.
Okay, good. One more question. What happens when a response to the first examination report is filed, but there is no response from the Indian Patent Office?
Yeah, this is again, we get this query very often. So a lot of the applicants do get tense because we have complied with the law, and it says 6 months from the issuance date, the patent office should actually put the application in order for a grant. But because of the huge backlog of a backlog at the patent office, the controller at times does not comply with this, and also many times the applicant does file it pretty late, the response. Once we have complied, as an applicant, we have complied with all the objections raised in the first examination report, there is no worry. You wait, and we sometimes send a status report. We ask a letter asking for the status, but even that is not needed. The controller will not reject the application. He will give the applicant a chance to respond to any further objections that he has, either in the form of a hearing or by a discussion, or he can just send you a second examination report. So there is no worry if the 6 months deadline has been crossed after filing your response or from the date of issuance of the first examination report. There is nothing to worry.
Great. Well, that's a great question, and thank you for that answer. So I just want to thank our listeners for joining us today. I hope you'll join us for the next program on patenting in Germany next month and other webinars that we have in other topic areas, including docketing and operations and automation. Thank you very much for your time today. We've reached the end of our time for our program. So again, thank you, Dr. Malati and Mr. Anu Garg. And thank you to our audience. Have a great day.